So tell me what we're doing with this.
Judge, this is a fugitive case. Mr. Day, I believe, is on Zoom. I am requesting to see if you would consider giving him a bond so he can go turn himself into
para que él se entregue
it's Yerpe County, Arizona.
a Yerpe, el condado de Yerpe en Arizona.
The lawyer is asking for me to set you a bond, Mr. Pasos.
All right, pause right here. This is where bond decisions get serious. The judge isn't just deciding money. They're weighing risk. Will this defendant come back? And are they a danger to the public? These two questions decide freedom or jail tonight. And listen closely. When a judge says, I have to look at several things, that's code for this is not going to be easy. What do you think matters more here? The past record or the current charge?
I don't know.
No sé.
I have to look at several things to see whether you would be a good candidate.
A ver si eres buen candidato.
Number one, whether you would actually go back. Number two, are you a danger to our public?
Segundo, eres.
So, Mr. Kim, tell me about Mr. Pasos, please.
Quiero saber sobre el señor Pasos, señor Ken.
Yes, Judge. This is the one from Yavapai County, Arizona.
Es que este es de País County, Arizona.
And he's wanted for charges of fraudulent schemes and artifices.
Por
Wait, fraudulent what?
Schemes and artifices. This is just how it's written.
Schemes and artifices?
Fraudulent conspiracy to commit fraudulent schemes and artifices.
Cometer
Okay.
fraude,
One count of computer tampering,
artificios, parece.
one count of theft,
Una cuenta de alterar computadoras.
and one count of criminal damage.
Uno de daños criminales.
So 4 total counts.
But it's out of the same transaction, Judge,
Casos.
on
Sí,
March 20,
por la misma
2023.
transacción que ocurrió en marzo 20 de 2023.
State would be opposed to a bond.
El Estado no quiere no está de acuerdo con una fianza.
For these charges, it looks like he messed with fuel pumps at a mini mart.
Estaba haciendo algo con las bombas de petroleras ahí en un minimart,
To include computer tampering,
incluyendo que estabas alterando algo con las computadoras.
but 1 year after he committed these offenses, he also was charged here
Este delito también lo acusaron aquí.
for a similar offense of violating motor fuel tax requirements.
Por violar los requerimientos de impuestos de petróleo y
And-
vehículos.
And briefly before that,
Y antes de
for
eso,
a misdemeanor charge of theft, but again,
un delito
regarding
menor de
fuel.
hurto, pero igualmente era de
He
petróleo.
also has a prior fugitive case, I see.
Tiene un caso antes de
I
fuga.
didn't see that when I pulled it up.
From 10/31/24, I see a prior fugitive case out of the same jurisdiction.
La misma jurisdicción.
Yavapai County.
Yavapai County.
So he's been before you? Is
what you
No,
say.
it would happen if he was
No,
a
dice-
fugitive and he was
Era
apprehended by
fugitivo,
another
y
state.
agarró otro estado.
It could have been by this warrant or another warrant,
Pudo haber sido estado de un arresto o otro.
Oh,
Una
be-
otra
but because it's resolved, that's why it's closed on our end. And I
but let me
can't
ask you
find
this.
it.
Did he know about this in 2024? Because if he did, I'm not giving him a bond.
he's saying he didn't know, Judge?
I see state jail. So I see a fugitive case and I see a state jail sentence of 7 months, both on the same time out of work.
De 7 meses.
So it looks like there
Entonces,
possibly could have been something that he pled to in Wharton County.
se declaró
He got also
algo
hit
en
with fugitive case.
Y le
Because he
dio un
got
caso
7 month sentence, they
fugitivo y
probably, didn't
recibiste
hold
7 meses.
fugitive case.
No fueron.
This is a lot of, we don't really know what happened.
So let's do this. Let's roll it to tomorrow.
I've had him in felony,
Dice
and I
que
know that he
yo
pled
en el
to
caso
the
de
7 month
felonía,
state jail.
sé que
And then
te
he was brought over
declaraste
to Harris
culpable.
I don't know if that helps, but
7 meses.
I
Represent him on the fuel tax in the 185th?
Pero ahí
Yes.
es donde
Oh my
voy a-
He did.
What are the
That's just
odds?
opportune.
Huh?
That's why I'm like, if,
Just go play the lottery.
so So, if that help, I don't know if that helps, but he was
So-
brought over.
Ella fue tu
from-
abogado, dice.
Sí,
Está hablando.
Did he do 7 months state jail? Because I show a sentence
No,
of
that's
7
still
months.
pending. So they're
No,
going to
dice que
send
se
him,
está pendiente.
Still pending.
todavía.
right.
7 meses de
Yes.
cárcel.
I know.
No,
Sorry.
there is ya terminaste, because when I had him, there was a hold. ¿Ya terminaste con el caso en Wharton County?
Yes.
Okay, because when I had him, he still had a hold. If there is no more hold, that means.
Run an
they're sending-
ACIC?
Yes. Temporary, how do you call it?
No.
I don't show another hold right now. I mean, there might be a warrant, but it's not attached to a spin that I can see.
It was
Ellos
there
no
when
ven
I had him.
What did he have in Wharton County?
Que tenía
If anything.
other words. Tenía algo.
It would have been a credit card or debit abuse. He was convicted
Abuso de tarjeta de crédito por
on
It's
October
the same
15,
thing over and
2024.
over and over. You know, it's over and over.
Dice que no lo puede hacer porque es la misma cosa de
It's-
vuelta.
Did you catch that pattern the judge just laid out? Multiple counties, similar fuel-related charges, and years of repeated behavior. In court, repetition is poison. Even if each case alone seems manageable, together they paint a picture. And judges absolutely notice patterns. This is where a defendant's history starts speaking louder than their lawyer. Question for you. Should courts treat repeat nonviolent financial crimes as seriously as violent ones?
It appears to me that Mr. Pasos Miranda continues to pick up the case
Sigue
over
agarrando
and over
los mismos
and over.
casos.
These fuel tax
Igual,
violations where
igual,
they allegedly get, you know what I mean? So we've got one in Wharton, we've got one here, now we've got one in Yavapai County.
Se llama Plan County.
So is it because of the types of cases he's picking up, or
Not
are we
this
going
one.
back?
tipo de
It's- It keeps happening,
Okay.
right?
Sí,
It's
no es por el tipo de caso, es porque sigue
it's over and over and over for the last three years, plus years.
What I was going to do, I thought we were going in a manner where I needed to figure out if he was aware of the warrant or not. But if that's not the case, and it doesn't make a difference.
Judge, may I jump in again?
Of course.
It looks like they lifted the hold
Parece que
on 218.
te quitaron.
If I'm looking on the DA portal,
Dos.
they placed a
18.
hold on him
Porque
on
pusieron una
October
orden de
31st,
detención
2024 for that
31 de
sentence for
octubre
7
para
months
la
state jail.
sentencia de
And then they
7
lifted
meses.
that hold
Después lo
on 218.
levantaron en
So he's done with that
18.
as of
Él ya
218.
terminó con el 18.
Yes,
de
I can show
febrero.
it to you. Well, I don't know if I can.
How?
Because he came in on a warrant, so his time would have
Él
ran
vino
concurrent
en una
while he was in
orden
Harris
de
County
arresto.
and we were
Entonces,
working
So
out.
you know what it is? It must have been, you know how on out-of-county cases, they give you the 10-day, right? And if they don't come pick you up, they release the whole within 10 days? That's what. it's
No,
probably-
well, so sorry, Judge. For this one, for the one on February 18th, that's for our 185th violation of motor fuel tax. That one, the release hold was on February 18, 2025. And then that triggered the in-county extradition for likely Wharton County for the out-of-county. That one was released on February 21st, 2025.
La orden esa te la quitaron.
But effectively, both of them, because they're state jail, it would have run concurrent. And at this point, based on when he was taken in, it's likely time served.
Which would be taking care of the Wharton County, and Wharton County is no longer in play because of the time he spent.
We don't know
here.
that for sure, though.
Well, we know that, well,
You
yeah.
know, right? So let's do this. Can we roll it to tomorrow and you can try to figure out?
Yeah, let
So
me
we have
figure
a
out.
concrete, you know?
Let me get everything in place. I'll roll it, try to get some confirmation on Wharton, and figure out if he had knowledge of this case out there.
I mean, I have a concern if he knows that this is open, because it's been open since 23.
Right.
Él sabe, de hecho está abierto desde
I get it.
2023
I'm gonna continue to, like,
Okay.
let him slide when he knows it's open.
Let me get all this in place and we'll reapproach. Okay, let's do that.
Bueno, deja de hablar con él.
Okay, thank you, Judge.
Thank you, Judge.
I'm here on two cases. The first one's on the docket, Malveaux, Malveaux. Judge, this is the one we approached, and I've been back a couple of times trying to amend the condition for the mom. This is an alleged assault family violence between a mother and a son. Ms. Malveaux is here. The state has agreed, and I think they've contacted someone to change her bond condition to, we were just going to ask to allow for the texting and the phone call, and then you would ask them to do some follow-up rips.
So the defendant is mom,
Yes.
complaining witness's daughter,
This is the, I believe,
Or is
15.
21 or 20?
Son.
The son is, he's 18, I believe he's a senior in high school. He's living with a family friend right now.
This next moment shifts the tone completely. We move from financial crime to family violence. And notice how protective the judge becomes. When a judge talks about temptation and monitoring contact, they're thinking prevention, not punishment. This is the tightrope courts walk, protecting victims while not destroying family bonds. Do you agree with the judge here, or do you think limited in-person contact should be allowed?
And we are okay with amending bond conditions to allow communications over cell phones, so they can still text and call. But we would ask the court to hold any in-person contact.
And Judge, we would ask to allow her to go to his sporting events. No contact with him there, but she'd like to go watch him at track.
Now, I mean, it's
And the
invariably
football.
going to happen where she's going to get overcome with emotion. Then she's there. He's 2 feet from her.
Judge, he'd be
Know what I
on the
mean?
field and she'd be
It's
on the
like-
stand.
It's like holding a candy in front of a baby. I'm sorry, not a baby, but like a 13-year-old kid.
Judge,
you
I
know?
believe she could stay in the stands and,
Malvo, come up.
and he'd be on the field, but
I don't know. I mean, I don't think that's
Jose Montes?
it's setting up for failure. I think. The only thing I want in the short life while I'm here is to protect every single complaining witness in these cases, in this county, in this state, as much as I can. And the problem is that temptation is so very high. We have at this moment a no contact order. You're not supposed to have any contact with this person. Your lawyer's asking for me now to allow you to have contact and texting privileges so that you guys can have some kind of communication. The state is still opposed to having you in-person contact. And the problem is that if you go to, and I'm inclined to, agree about in-person contact. The problem is that if we allow you to go to these sporting events and he's 2 feet away from you, the temptation is so high, it's invariably going to happen. And we're not there to see whether it happens or not. And so therein lies the problem, is that I will never be able to monitor the fact whether you actually have contact with this person or not. And that's a problem, because the last thing I want is you to pick up more cases or this person to get more hurt.
talking about in person. Y'all have him as 18?
We actually have him in the up the Erupt phase 16.
Yes, Judge, he's 16. He's not 18.
The birth date was listed wrong.
It's okay.
And his father's in jail.
Remind me about the assault, please.
Sorry, Your Honor?
Refresh me about the assault, please. How bad?
So-
We're talking.
Yes, Your Honor. So the assault took place in June 2024, and the victim was identified, and the victim explained how his mother, the defendant, assaulted him by biting.
Biting.
Yes, Judge. You see. So the victim stated his mother was angry that he was in the way, and as he was holding her 2 wrists, she raised her hand up to her mouth and raised his hand up to her mouth and bit his hand. The victim stated he felt pain, was in fear, and the victim had a visible bite mark on his hand.
Judge, the son is holding her first, just so we're clear on what's happening.
I mean,
Yeah,
Yes,
but
it does
he's
say
not
that.
quite saying that.
Well, it does
I
say
mean,
fully
what
that.
circumstances happen to where a 15-year-old grabs mom, right? I mean, perhaps they were fighting, I don't know, but the fact
Judge,
remains is that
there's been no facts and nothing in the probable cause that I've been given or that I've shown that any of this was between the mother and the son. I believe it was between my client and another lady, and the son comes and holds her. I believe that's what the
So-
facts will bear out.
he's trying to protect her. He's trying to, I guess, de-escalate the situation.
Judge, I believe that those would be facts that I would want to
Right,
try.
I mean,
yeah.
I don't know,
Right.
and so, right,
Yes.
same thing, I mean,
Those would be
regardless, but we
facts
do
that
know,
I'd want to bear out, but it's not like she just walked, I didn't want when you're making your decision for you to be basing it on, what it sounds like she walked up to him and bit him. That's not how it happened.
I get it, thank
Thank
you.
you. Thank
Because,
you.
and, I mean, the idea is that we really want to know under what circumstances everything happens. That's why with every case that we have here, we really delve into it as deep as we can to determine, is there probable cause? What circumstance should we have as far as contact or no contact? Guys, what do you think?
Judge, we're okay with them texting and calling each other just to catch up.
What does he want? I mean, at the end of the day,
So
we need to find out what he
It's a little bit of a
wants.
complicated situation in terms of the complainant's guardian, because he is 15 and said he's living with a family friend. What we do know is that he does not want, to be living with the complainant, with the defendant. He wants eventually, I think his eventual goal is to get emancipated. We do know that, we talked to the person that she's living with and says that they have been texting already, so because of that, we're okay, and that they're
You
okay with
texting
it.
already in violation, but no contact order? If that's the case, I mean, I've got it. We'll take issue with that.
So, this was based on the talking to this parent, she wasn't entirely sure.
Do we have a no contact order now?
I'm not, Your Honor, not entirely sure. And the other thing is that we haven't confirmed that with the complainant itself, the 15-year-old, so at this point, we don't have evidence to move on a
Right.
violation of the protective order or anything at that point. But it seems like the kid is okay with calling and texting, but hasn't.
But you don't know that
they
for
don't-
sure, though. You don't know that for sure, right?
That's correct.
And Judge, as of December 18th, 2024, there was a no contact order in place.
I hope that you're not having contact with this
I'm
person.
not having that.
I hope. Just, let's do this. Why don't we set this off for a couple of days? If you could please reach out. I want to know what he wants or she wants.
Judge,
Taking her in school is really hard.
I want to honor the complaining witness's wishes.
we've,
This is that they just don't know.
well, Judge, can I just recount this? We've been asking them to know this. This is the very first time I was appointed, I approached you on this. You asked them the exact same questions. They've done nothing. They can't get in touch with the complaining witness. I came back on February 2nd. I came back on February 3rd. I came back on February 10th. I came back on February 11th. I came back on February 12th.
I agree with her. That's kind of, that's,
And that's why at this point, we are agreeing to have that full connection, which is what.
but you still don't know.
We have talked to the guardian, just haven't particularly talked to the kid. The legal guardian is an aunt who does not live with the complainant. Who we're talking to was a family friend, we've talked to her, we've given her multiple calls.
So,
We just haven't been able to get.
so let's do this.
Judge,
Let's-
that's a misstatement. The sister's not the legal guardian. The son is living with a family friend right now. His father's in jail.
The complaining witness is a boy or is it a girl?
He's living with a
It's the boy.
schoolmate, Judge.
A friend from school.
He's living with a friend from
His
school.
dad dropped him.
And she's going to do a
And went to
BIP. The
jail.
chief has offered a BIP and dismiss.
I get it. I understand.
A BIP and a parenting house. Sorry. He did tell me that, Judge.
I understand, but I always want to honor the complaining witness's wishes, right? So let's do this. I do find it unreasonable that they've been here as many times as they have, and you guys have been unable to do this. So what I would suggest is do this. Reach out to them and say that we're going to subpoena them to come to court if they do not get in contact with you guys. Because I agree with you that it's unreasonable to have to come back 4 or 5 times just to see. So let's set this off maybe like 3 days, 4 days. Reach out to them and say, hey, we are going to subpoena you to come to court. If you guys, all we want to know is what's going on and whether you guys want to have contact and in-person contact as well. So ask everything so that you guys don't have to come back. Anticipate every single question that they're going to want known so that you can.
Yes, Judge.
So what we can do, you don't have to waste your time coming to court. We can set it off 3 days, 4 days, and I'll waive your next appearance so you don't have to come here. And then she can reach out to you, phone that, because I don't want you to have to miss work or whatnot or anything. But I have to know what they want. And I don't want to work on speculation because
Is it what my son wants or is it?
it's what the son wants. I don't care what the guardian, I don't care who the guardian is. It's what the son wants. Right. I don't care about a guardian. It's not their decision. And I think that now 16?
16-year-old.
He's old enough to know, right? He's almost an adult, so he's old enough to make decisions on his own at this point.
And Judge, I've already accepted the PTI. We will get started on that. So even by this next setting where she doesn't have to appear, excuse me, Judge, she'll already be underway on the PTI.
Okay. I mean, parenting class is probably pretty short, so it's,
It's
you know.
BIP and parenting classes, Judge, I'm sorry.
What is it?
It's BIP and a
Oh,
parenting class.
BIP and a parenting class. Okay.
I'm not really sure. I've got to figure out how long they want her in BIP and talk to her about that.
Got it.
So
Okay.
you can go sit down just for a second, then we'll get your case reset, okay?
Okay.
All right, we'll keep trying. Judge, I have one other one on docket today, and it's just a reset, and I've just been appointed today. Do I have to approach you on those? You've already found probable cause. It's Mr. Hall falsifying the drug
No,
test allegation?
no,
All right, then
no.
I'll just.
Just let him know that he's going to get drug tested about 50 days, just so
Yes,
he
sir.
knows, and that's it.
Thank
Okay.
you so much.
Thank you, Mr.